out of Richmond, Virginia, where I work with a lot of small and medium-sized businesses. So a lot of my clients are going through what many of you are going through right now, and there are a lot of questions. There are a lot of questions right now because this is something that we have not been through, the world has not been through in a very long time, let alone our generation or many of our businesses. So some of the most pressing questions we're getting right now, the most immediate questions, really have to do with your obligations under contracts that you are currently in, or others' obligations to you in contracts that you may have with them. So a lot of the questions that I'm getting right now include things like, okay, do I have to still keep performing this contract? Does my client still have to keep performing this contract? Do I need to refund? What gets refunded versus what doesn't? How do I deal with refund demands, even if I have a non-refundable retainer clause? So at the root of a lot of these questions is one overarching question, and that is, does COVID-19 mean that my contracts are now canceled? Because there are a lot of things that are preventing us from performing under these contracts. And when I say perform, I mean simply like doing what you're supposed to do. That's what we mean by perform. So, if you in a contract have agreed to paint somebody's house, performing that contract means painting the house. If you have agreed to pay somebody, performing means paying that person. So it sounds a lot fancier than it actually is. It really just means you doing the thing that you were obligated to do under that contract. Now, people are throwing around a lot of language, a lot of internet scholars are saying certain things and maybe not quite translating the very complicated legal around all this. But one of the words that you're going to hear a lot is force majeure. And so I'm going to talk a lot about that today because I think that's really going to help the most people in these situations. Now, what is force majeure? Force majeure is essentially a contractual defense. So it is a defense that's written into a contract that allows a party to delay or suspend or even get out of performing certain things under a contract under specific stated circumstances. These circumstances are usually things that you couldn't have foreseen or things that you don't have any control over. So when you write it into a contract, you say certain things like, fire, flood, act of God, that kind of thing. So force majeure is not necessarily implied in contracts in the United States. Some other countries, they imply force majeure, which means they'll just kind of stick it on in there. But in the United States, we have to have it written into our contracts, and that's just the way that we work. So what constitutes a force majeure event is going to be determined on a case-by-case basis based on what's in your contract and the applicable law in your state. In our state is Virginia, that kind of goes into interpreting your force majeure clause. To trigger that force majeure clause, most of the time the event is going to have to be unforeseeable, and it makes it impossible, now note I say impossible, for you to actually perform, so for you to do the thing, under your contract. Impossible means like you can't do it. It's not just a lot harder. So impossibility isn't, oh no, it's going to cost more for me to do my job under this contract, or, oh, I can't do it on this day, so we're going to have to move it to another day. No, that's not impossible. That is modified. Like you can do something under the contract. And that situation, your performance would be excused until that date, or, maybe you would be able to modify your performance a little bit, but it's not going to cancel your performance just because it's a lot harder to do. It has to be impossible or almost nearly impossible. So in general, you are going to see courts in a worst case scenario, right? Somebody decides to sue somebody else because they didn't perform and someone's claiming force majeure. You are going to see courts interpret any force majeure clauses in your contracts very narrowly and based on the other terms of your contract. And that's why we say over and over and over again, like, it is really going to depend on your contract. So when we say, like, okay, well, what's required for force majeure? First, you have to see it in your contract. You have to have a list of events that are not reasonably foreseeable and that are beyond your control. So those are the things that we are looking for. Like I talked about before, your performance has to be impossible, not just difficult. When we say impossible, impossibility probably does mean, okay, the governor has now made us unable to leave our residence unless it's an absolute emergency, things like that. That's going to probably be considered impossible. That's also going to be something that may have been included in your force majeure contract under a clause saying something like government mandate. If in your contract you have, this contract may be excused under force majeure for fire, flood, acts of God, civil insurrection, government mandate, or any other event beyond our control, that's probably as encompassing as you're going to get. No one has pandemic in their force majeure clause right now. Almost no one does. There are some people that do. So a lot of us aren't going to be relying on pandemic language. You're going to be relying on things like government mandate or, any other event reasonably beyond the party's control that makes them unable to perform. So that's the language you're going to be looking for. Now, I keep getting ahead of myself because I get excited and I just keep talking about things without hitting the PowerPoint. I can't stress enough that it really does depend on what's written into your contract. And if you don't have a force majeure clause written into your contract, I will touch on that in a few minutes. But it's really important to look at not only your contract, but the facts in each situation where someone, whether it's you or another person, is trying to invoke a force majeure clause. And that's because everything has to line up correctly. Like, the planets do really have to align in order for you to take advantage of it. Now, a global pandemic such as COVID-19, we are not sure if this is going to count as an act of God or not. We don't have a lot of information to go off of in regards to whether this is going to be considered something that is an act of God. So if that's all your contract says, you might not have the ability to modify your performance based on an act of God. There are not a lot of great answers right now, and I know that it's a little bit frustrating, but the last time we really had to encounter something like this was the polio epidemic, and then before that, it was the Spanish flu. So there's not a lot of guidance from courts whether COVID's going to be considered an act of God. I am of the opinion that it's probably not going to be considered an act of God, so that's why I'm telling my clients to rely on the language in your contracts that say government mandate or any other event outside of your reasonable control. So that being said, if you do have a force majeure clause and you do have things in your contract that say government mandate or something reasonably outside your control, what do you actually have to do? Like, what is your job now? Whether someone is trying to invoke it to stop performing or whether you are trying to invoke it to stop performing, because you have like you and the other person involved in your contract. Basically, there are two requirements. Once we figure out, okay, we're in a force majeure event, there's a force majeure event happening. My contract falls under this force majeure event because everything that I'm supposed to be doing is hindered by the government mandate, by the events outside my control. So how do we move forward? The first thing you need to do, and that you are responsible for doing, or the person who is trying to invoke or delay their contract based on force majeure, you have to provide notice. Notice is really important. And what we mean when we say notice is you need to tell the other party, hey, we've got a problem. And it's based on all of this stuff. Now it's obvious that like if your contract is immediately going to be affected, like a one-on-one contract, your contract with someone else is affected, you can't perform, okay? Maybe it's a situation where you were supposed to go help, maybe you're catering and you were going to go cater an event, and we're no longer allowed to cater events. Like businesses are supposed to have closed. So maybe you are directly unable to perform. But you need to think a little bit bigger than that, because you need to start thinking about things like your supply chain. Supply chain management is likely to be interrupted. If you are involved in manufacturing, if you are involved in sales of particular goods, maybe you rely a lot on imports from other countries, maybe like China, maybe Europe. These are all situations where your supply chain may be interrupted by the COVID crisis. Think about other things like shipping inside of the United States. Even shipping inside of the United States has been delayed right now. So think outside your immediate like me and them contract. Think kind of into the bigger sphere of things, because the sooner you can provide notice, the easier it's going to be to mitigate and to deal with and to prevent future harm based on a force majeure event. Now, I will say, don't jump the gun and say, if you don't have a reasonable belief or reasonable knowledge that there is going to be some sort of effect, don't jump the gun and say like, hey, we're not going to be able to perform this contract because we think there's going to be a force majeure event sometime. We're not really sure, but we think there might be. Don't necessarily do that. That might end up kind of being a breach of contract instead of force majeure, because if the events that cause force majeure don't actually happen, you don't actually get the ability to claim that defense. So like I said, force majeure is a defense. It's not a weapon. So you can't just be like, cut down a contract because of a force majeure event. That's not how it works. You can simply defend the fact that you can't perform, so you can't do the thing because of the force majeure event, okay? So don't jump the gun. Make sure you have a reasonable belief that there is going to be a force majeure delay or non-performance under the contract, and give that notice. Now, when we say notice, again, your contract may have a notice clause. So go through your contract and see if there's a clause that says notice. It's usually towards the end. It's usually in that boilerplate that nobody reads that actually comes in really handy in times like this. So it's probably in that area. And notice will probably give you a step-by-step form or way to contact and provide actual notice to the other party. So it may say by written notice. It may say written notice, certified mail, return receipt requested, something like that. Just make sure you follow those directions to ensure that you are giving notice properly under your contract. The next thing you need to do is mitigate the damages that are being caused to the other party. So if you are the person that is being affected by the force majeure event, or you are affecting someone else by the force majeure event, on either side, you are responsible for not making the problem worse. What that means is if you have been told by someone, hey, we're having problems, we're not going to be able to perform. Let's take that catering example again. Maybe someone's saying, hey, our event was supposed to be on this day, and because of the government mandate that says we can't go out of the house or we can't have gatherings, we're going to have to modify our contract with you, push it to a later date, something like that. You, as a service provider, can't just be like, nope, never mind. Like, I'm just going to order anything anyway. Like, I'm just going to keep on doing my job. You are responsible for not doing that. And on a reasonable notice from them, you can't just necessarily kick this into gear without notice, either giving or receiving notice. But you need to do things to try and soften the blow, lessen the damages, whether the damage is financial, maybe it is a PR situation. You have to try and figure out alternatives, or look at the burdens and costs of moving versus canceling and all of that kind of thing. Get creative and start thinking out of the box of ways that you can try and assist in the situation, because you're actually legally obligated to try and pump the brakes a little bit. Don't just keep on keeping on as if this wasn't happening, because it clearly is. We're all stuck in our houses. Make sure you are helping out your fellow party under a contract. All right, so there are a couple situations, though, where you may not have a force majeure clause, and I understand that, especially if you're working on purchase orders, or you don't have an overarching master service agreement. You will not be able to take advantage of a force majeure clause if it's not written down, and that is why we do go through contracts and have lawyers draft them, because we like to put those things in there. But if you do not have one in your contract, you are not completely out of luck. There are very, very narrow, and I don't like to rely on these, most lawyers don't, but there are very narrow sort of common law, and common law is like not written down anywhere. It's just made by judges and floating around out there. Common law solutions called impossibility, impracticability, and frustration of purpose. And they may apply to your situation. They're construed very narrowly, and the facts, just like we were talking about where force majeure has to line up, right? Like impossibility, frustration of purpose, that all really has to line up correctly. So if there's a situation where you absolutely 100% physically cannot perform, like the ground opened up and ate the music hall or something like that, that's definitely going to be a place where impossibility is going to come into play. Here, I don't know if that's going to come into effect or not. We're kind of waiting to see what's going to happen. So you're not completely out of luck, and keep that in the back of your mind, but it's not something we like to rely on. So just wanted to make sure I noted that for you guys before moving on. Let's see, time. Okay, cool. Great. We're still good on time. All right, so now what? Now that we know all this stuff, what do we do if we are either giving or receiving notice of a force majeure, and we have got to figure out what our contract needs, or what we're responsible for, or what we have to mitigate, or how we got to line this whole thing up to make sure we are not damaged more than we need to be? Because there is going to be some fallout from contracts that can't be performed, or things that get stuck places, and maybe food expires, or pieces of goods don't make it across the border, or don't make it because they're not shipped in time. There are going to be situations where we're dealing with that. So we just have to figure out how to best soften these blows to your business. All right, we're giving force majeure notice. We are saying, hey, other party in a contract, we can't perform because under our contract, you can see we've got a force majeure clause, and we're pretty sure that we're in a force majeure event. We can't give you what you need and what we are obligated to give you under this contract. So here's how we're going to handle it, okay? First, you need to timely comply with notice. We just talked about notice, what you have to do when you give notice. Make sure you're checking your contract, and do that in a reasonable time. Like as soon as you can, not by jumping the gun, but as soon as you reasonably believe that there's going to be an issue, contact the other party to a contract. Contact your downstream people, maybe if you're in manufacturing. Anybody that you are, your wholesale suppliers, anything like that that you think may be ripple affected by this, contact them and let them know that there might be an issue. This is also just outside of a legal perspective. This is a good business practice because you want to try and preserve relationships where you can. So by giving people a heads up like, hey, something might be happening, you're helping them pad their own, just kind of pad their own business and deal with the fallout that may result from you not performing in their ecosystem as well. Next, just again, think through the potential consequences like a ripple. Think through immediate, move out a little bit, move out a little bit, move out a little bit. peel those layers back like an onion, because as you know, when one thing gets hindered, there may be issues with other parts of your business or other product lines, other effects on other businesses, things of that nature. Then something that's good, and it's not necessarily a legal remedy or it's not necessarily a legal thing, but look at your insurance. Determine whether there is insurance coverage available for you, which may include things such as business interruption insurance. Maybe if you have an event-specific insurance policy or specific riders on your business insurance based on particular events that may be taking place right now. Now, I will say there are a lot of insurances who are not including COVID in their coverage, or who have, moving forward, carved COVID out of their coverage. So it's going to be really important for you to look at your individual policy to see what applies. But one of the things that I discussed with a fellow attorney who used to be in insurance defense is that even if you get a rejection, even if they come back and say like, hey, we're not going to cover that, push back a little bit. I was discussing with her, she worked for an insurance company, and she said a lot of times their policy was just to initially refuse to cover things just so that they could see who actually pushed back, and then they would deal with it from there. But some people just wouldn't actually push back at all, and they wouldn't get coverage. So I would encourage you to investigate what it looks like to push back. I asked her who the best person to go to for this was, and she recommended personal injury attorneys because they deal with insurance a lot. I don't know if that's going to actually be beneficial or not. I have not called any personal injury attorneys about this, but they often offer free consultations because of the way that their pay scale is set up. So that might be worth looking into. And then finally, what you need to do if you are giving force majeure notice, document all the steps that you're taking to get around it, to mitigate damage, to try and avoid the impact of COVID-19 on your business and on the other person, the other party to the contract. Document everything that is harming your ability to perform. Document any other facts and circumstances and steps that you've taken to provide notice, to soften the blow, and to get creative with your options and other ways that you can work around this roadblock that COVID is giving all of us right now with respect to performing a lot of our contracts. All right. So if you are receiving force majeure notice, so that's different. So someone is opposite of you and they're saying, hey, we can't perform our side of the contract because of this. So this is the opposite of what we were just talking about. What we just talked about was if you're giving it, now we're talking about receiving it. All right. First, you need to evaluate, okay, whether this person's force majeure notice, it actually falls within the law and within the confines of your contract with them. It may not. If it doesn't, they can't necessarily claim that there is a force majeure event occurring or that the force majeure clause counts or matters right now. You need to make sure that they gave you the correct notice. Make sure that they went by the clauses of the contract that define what notice is and how it needs to be given. And then you need to figure out how and when to respond to this. If their performance and your performance is just excused, like can it be pushed back? Does it just get delayed? Like what does that look like? So talk back and forth with them and figure out if this is something that can be moved or if they just need to be completely terminated this based on the force majeure event. And remember that just because someone is terminating a contract based on force majeure, it does not mean necessarily that you have to give back all the money that was given to you under the contract. There is a lot of, again, I didn't push the button. There's a lot of confusion about whether force majeure rescinds a contract, and rescind means nulls it out from the beginning, makes it null and void, and puts everybody back as if there hadn't been a contract period, or if it just terminates it. So it kind of like cuts it off before it matures. So the answer is really, it should be written into your contract, but most of the time it's going to be, it doesn't rescind the contract completely. It just stops it from going any farther, and it stops people from having to perform further, and it stops people from having to make additional changes and incur additional expense. So if you are on one side of a contract and you have incurred expenses or you have done work based on the contract and somebody saying, oh, okay, like we got to stop because force majeure, that doesn't mean that you necessarily need to refund all of the money that you've been paid or that you need to pay back a non-refundable retainer, because the contract, the force majeure clause isn't necessarily meant to completely void out the contract. You have the ability to be compensated for the work that you have done up to that point. Okay, I think that's all I have right now. And there are questions I know that we said we could talk about. And this is my contact information. If anybody has any additional questions or needs help, we are available there. But all right, I'm going to exit out. Yeah.
Thanks, Caroline. Thanks so much. Like Caroline said, we do have lots of time for question and answer. That's why these are just for you, the folks that are here. So again, we're going to open it up to live Q&A. This is your opportunity to ask the legal questions that may be affecting your business. And we have an expert here that can help. So if you would like, you can do, again, one of two things. You can raise your hand now. And what we'll do is we'll open up your mic so that you can ask your question. By the way, when we do open up your mic, you're going to get a prompt on your screen that says the host would like to allow you to speak or something like that. And then you click accept, and then you can ask your question. The other way, if you're a little bit shy and you don't want to ask it vocally, you can do it and by typing it. If you click on the Q&A button that is on the bottom, it's the bottom center of your screen, the rightmost button, it's called Q&A. You can just click on that button and you can type your question into Caroline, and Jasmine will be able to read the questions to her. Okay, so we're going to open it up, and Kat, I'm going to turn it over to you for any hands that are raised.
All right.
We have no hands raised.
Okay, so I have a question, Caroline, for you.
Sure.
Okay, one of the things you mentioned is what are the things that you would include now? I run an event company, and one of the things that we're seeing is there are some cancellations, but then there are postponed types of things. And a lot of people that I have found in my industry don't have a clause for something being postponed, or if they do, it's very, very generic, meaning that it says, you and I will agree on a mutually beneficial date in the future or something like that. What happens, or what language would you suggest that might be better for postponed types of things, or something where it would, like, we're not saying no, and it's not a cancellation, so it's not really force majeure, but we need to do something in the future.
Right. I actually work with a lot of event professionals, so I have answers ready for you because I've been talking to everybody about this a lot recently. So when you have what you can't do is you can't go back and change all of the contracts that you have right now, right? So it's like we're going off of what's already been signed and already been written in. So most of the time, if you have a postponement agreement in a contract, it does say like we're going to agree on a mutually beneficial or a mutually agreed upon date. That is usually pretty good language because you are going to not be able to nail something down on the front end. Like, if it's very difficult to figure out if this kind of situation is going to happen, what a mutually agree upon date is going to be, blah, blah, blah. One of the things that I have had in my event folks contracts is, okay, if we can't come to a mutually agreed upon date, or you pick a date that I'm not available, this gets treated as a cancellation. Because if you think about it, you're giving them the option to postpone. So it doesn't, so you have given them an alternative. So performance is still possible. So your performance is not impossible anymore, which means, okay, well, we don't have to deal with necessarily this contract being terminated because of non-performance, or we don't have to deal with the fallout of, all right, well, I can't accommodate you. It's, I can accommodate you. We agreed to pick a date that I was available. and you chose not to do that. So then you would go by the cancellation clauses in your contract. If that's not in there now, we can't really do much about it. So it's kind of just figuring out where all those pieces fall into place. But that is how I have organized most of my event professionals contracts.
Okay, thank you so much. I'm going to turn it to Jasmine. I think she's going to ask a question. Okay.
Yes, I actually have two questions. The first question comes from our comments, and it's from KK Shuff. I'm sorry if I'm saying your name improperly, but it says, to understand clearly, without a FM clause, does that rescind a contract and not terminate it because an event is canceled?
It depends. Oh, God, I hate that answer, but it really does depend what else is in your contract. Does it, if you don't have a force majeure clause and the event's canceled, I mean, it depends on the event, what the event was, when the event's scheduled, if there are possibilities to perform or to not, when, again, it's a little bit up in the air right now because there's that chance of impossibility or frustration of purpose. If the event can't happen, period, if we're in a situation where we're on lockdown and the event can't happen, period, there is a argument that the purpose of the contract has been frustrated. But at the same time,
KK added she's a wedding makeup artist.
Yeah, so I think that you can, I mean, I guess it really does depend on what's in that contract itself. That's a crappy answer, but it's kind of like, all right, well, what does it say about cancellations, postponements, and things of that nature? If there's nothing about postponements, there's nothing about cancellations, there's nothing about force majeure, there's nothing about X, Y, or Z, I would argue that they could cancel the contract and you'd have to refund them. But again, it's so fact specific.
I understand. We're going to go to one more Q&A, and then I'll pass it over for some hands that are raised. So another question comes from Charlene Reynolds. She says, I have a response to your question. I am an insurance agent. The solution would be to purchase special events insurance for future contracts. The cost is inexpensive. So I'll take the question.
So what I have found out, though, is that a lot of the special event insurance that that you would be taking out does not include COVID-related stuff. Andrea's shaking her head. Yeah, they have carved that out, so it doesn't include all of that, which stinks. Yeah, but I'm glad there's an insurance agent here because that is stuff that I don't know about. And I'm always like, go talk to your insurance agent.
Alrighty, I'm going to pass it over to you, Kathy, to answer some questions. I know we have a hand raised.
The next person we have is Miss Miller. I'm going to go ahead and allow you to talk to ask your question. And you are live.
Hi, everyone. Thank you so much, Caroline, for sharing such valuable information. And it's very, very timely. So I, too, am a makeup artist, and we have a lot of brides that we're working with. KK is actually my counterpart. So I wanted to ask a question that kind of piggybacks off of what Andrea was talking about with clients who are rescheduling. So I fortunately do have force majeure language already incorporated into my contracts. However, I don't have specific language around postponing or rescheduling. So I've been writing copious notes about some of the keywords and the language that you provided, but I wanted to know if you could maybe follow up, or maybe I follow up in an email, and provide boilerplate or templative language with the specific wording that we should include for postponements or rescheduling.
Yeah, that would be something that we'd have to handle through the law practice, honestly, just because that does involve like me using my license. So if that's something that you're interested in, you can absolutely contact us. My email I gave you in the previous slide, it's just caroline@cjfoxlaw.com. And we'll have some questions for you about it because they are really, really specific based on your business, the way you structure things, your payment structure, that kind of thing. So in situations like this, there's not necessarily boilerplate language per se, but I'm happy to work with you and figure something out.
Okay, thank you. Again, very valuable information.
Good, I'm so glad.
I know we have a couple more questions in the chat and Q&A. One comes from Jeremy Haskins. He has two questions. So the first one, does the force majeure clause need to specify the unforeseen event type?
So, great question. Force majeure is construed very, very narrowly, not quite as narrowly as the impossibility and frustration of purpose, but it is really construed pretty narrowly. So you want to have a list of potential things like event types, like you're saying. You want to see the type of thing in there. So yes. So like I said, most people aren't going to have pandemic. Like, let's just face it. We have not dealt with pandemics since the Spanish flu and kind of in polio, but like not really. So people don't have that clause in their contracts. And if you don't have that, which most people don't, we're relying on government mandate, possibly other unforeseen instances outside of the control of either party. That may work. But what I like to see and what makes me feel more comfortable, and as an advocate for somebody, if I can see something that says government mandate, I feel good about that. But yes, you should be listing specific circumstances in your force majeure clauses.
And this kind of goes along with your response, what you just answered. What's an example of too vague language?
Yeah, too vague is just going to be like, in the event of a force majeure event or an act of God, blah, 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 blah. So you want to definitely specify. I mean, my standard, like, rip it off and go clause would be fire, flood. If you're on the coast, I'll put in stuff about hurricanes and tornadic activity. Mm-hmm. I've done some contracts for areas where earthquakes are common. I'll throw that in there just because it's no question. Like it becomes, okay, well, are those acts of God? Yeah, those are almost definitely acts of God, but do we want to be caught fighting about it? No. So if there is stuff that you know might happen or you have a reasonable suspicion could happen, throw it in there. And then I always like to throw in government mandate, because anytime the government makes a rule that you can't go somewhere, or maybe we do have a hurricane or really strong winds, or maybe there's just like a suspicion that there's going to be an ice storm and the government decides they're going to close down the airport. I don't know, airports. Do they close those down? Whatever. If the government does something where you can't get out, you're going to be covered, even if you don't have that freak incident or weird situation in your force majeure clause. So I thought of something else and now it slipped my mind, but if I think about it, I will say it.
Awesome. Thank you.
Oh, I remembered. Sorry. I just talked to a bunch of people from Atlanta where this is a huge problem as well. I had stopped putting in civil insurrection in my force majeure clauses about 6 years ago. And then after Charlottesville, which those of us in Richmond definitely remember all the stuff that happened in Charlottesville, I started putting that back in. So maybe that might be something that you want to throw back in too. And I bring up Atlanta because I was on a call with a few ladies yesterday who have had situations where there have been protests and marches and or riots that have impeded their ability to perform under contracts. So maybe throw that back in.
All right, I do have a comment from...
We are now at the 15-minute mark.
Thank you. We do have a comment based on what you just answered. After this comment, I'm going to pass it over to Melody because I know she does have a question as well. But the comment says, we run into this. It's from Inedra Byrne. I'm sorry if I'm mistakenly saying your name incorrectly. But it says we run into this with a contract that covers our vendor, but not our org directly, as it does not specify reference quarantine among other categories. We are trying to negotiate the contract, not cancel entirely, but it is challenging. So not more so of a question, just the comment that she did.
Yeah. Yeah, it's really hard. This is not simple stuff. Like if this was simple and cut and dry, first of all, I mean, we probably wouldn't have as many lawyer jobs as there are, but if this was cut and dry, there would be an easy answer, and there's not. There's really not. We don't have much to go off of. So, I mean, don't feel like, oh, we did something wrong, or like, oh, we should have known better, because A, you only know what you know, and B, it is going to be tricky, and there's going to be a lot of litigation that follows up on this. And I was just talking to an older colleague of mine today, who is, I guess, in his 70s, and he was just saying this is going to completely change contracts as we know it. So everybody's kind of dealing with this really uncertain ground right now.
It's all new.
Yeah, exactly. It really is.
Mm-hmm. All right, I'm going to pass it over to Melody. I know she has a question. Oop, you're muted, Melody.
I got you.
Can you hear me clearly?
Mm-hmm.
Yes.
Okay. All right. So my question is, what would you suggest to an owner of a bed and breakfast that has received cancellations for half of March and all of April for multiple locations? And when we're placing our calls, we're saying, checking in on their family and friends initially, and then we get into the business of asking, would they welcome a credit toward a future stay?
Mm-hmm.
Because when this is all said and done, we're all going to need a vacation. We're all going to need to be spoiled, right? And, about 30%, maybe 40 have said yes. The others, they may have been traveling to the city for a reunion or, things one time only. And if that's the case, they may be canceling within the cancellation period. Do we have any legs? Like, are there any legs for us to stand on? And the other piece is we want people to still book with us when this is all over. So we don't want folks to be so upset with us. Yeah. It's really about cash flow. So is there any suggestion as it relates to the people that are insistent upon getting their refund?
This is especially tricky for hospitality and events. Like I said, I do a lot of work in this area, and they were kind of the first ones hit. So I've had a lot more time to work with this area. But I will say at this point, there are considerations on legal versus business and PR. So we do have to start spinning in, okay, these are the legal rights, and then this is the PR implication of that. So while I would have to see the contract between not only, the book or the bed and breakfast and the client, there would probably be a contract. There's also probably some contracts based on if it's getting booked through a third party, like Hotwire, like whatever third party bookings, or Airbnb, those kind of services. There's probably a contract there too, and that you guys have both agreed to those terms. So you have to figure out what those terms mean. And do you need to refund this group of people different than this group of people? So trying to figure out what that looks like as it relates to legal rights. And just looking at, okay, this part of the contract falls in here. This is force majeure. This isn't. For those people that are on force majeure, can we require a postponement, or does it have to go into a cancellation? So it's all these building blocks of a contract that need to get looked at. Mm-hmm. And then also, in tangent with that, we're worried about getting trashed online on Yelp reviews and on hotels.com or anything like that, any review site. And that's a definite concern. And one of the things that I have encouraged folks to do is to get everything in writing. And if it is possible, if there is a situation where there may be confusion or lack of clarity, or maybe you are worried about getting bad reviews, and so you want to kind of go above and beyond what you're meant to legally. Get stuff in writing, and then if you're giving something additional, like you can't just do this if you're already obligated to do it, but like if you're giving an additional, like maybe you don't have to refund them, but you're refunding them 50%. Or maybe you don't have to, maybe you can keep the non-refundable deposit, but you are going to refund 75 or 50% of the non-refundable deposit. Anything where you're giving a little bit more than you are obligated to give under the contract already, you could go and this is a little bit tricky, but you could do something where you essentially reach a settlement and agree to a confidentiality, non-disclosure, and non-disparagement, saying like, we agree to give you 50% back. We only have to give you 25. We're going to give you 50. Or we don't have to give you anything back at all because you're in the cancellation window and this doesn't technically matter in our contract, but we're going to give you 50% back. But you just have to sign this non-disclosure and non-defamation or non-disparagement clause. That's a tricky way of doing it to make sure you don't get as like beat up online. I know that it's not great. There are cash flow issues that everybody's running into, and it is going to be really tough on hospitality. That being said, it all does go back to that initial contract and what it says and what you have to do and what was signed at the very, very beginning.
Okay. All right. Thank you, Caroline. I appreciate it.
No problem.
Caroline, we have about 8 minutes left, and I know there's 4 questions.
Okay.
So I just want to let you know we can kind of lightning round this a little bit so we can make sure we get through everyone. And I know there's also a hand raised. So lightning round.
Got it.
And anybody else wants to raise their hand, now's the time.
So question, Vernice Love, could you please reiterate the other 3 possibilities if there is no force majeure clause? I know one was an impossibility. What were the other 2?
Sure. You could look at impossibility, impracticability, and frustration of purpose. They're all kind of lumped together, but those are the 3.
Perfect. Cindy Richardson says, asking for a fellow business owner. She owns a dance studio and feels the language in her contract, locks her clients in, and they have to continue to pay the monthly fee. Some of her clients have already started talking about lawsuits, and she's uncertain of what to do. Any advice that I can offer her besides seek an attorney?
That's the advice that I would give her. Honestly, it's going to depend. Yeah, she's going to need to review that.
Next question, Maurice says, in the event you don't have a force majeure language in the contract, I was told that you can add an addendum to the contract. How true is this? I apologize if you've answered this already, which I don't think you have.
I haven't. I have not. You can only add an addendum if you are adding that additional like little bit of something. So you can't just willy-nilly be like, all right, I made an addendum and now you have to sign it if you want to keep working with me. You can't just do that. You have to add some little bit of bargain. It's called consideration in legal language. So you have to add something else to make that addendum effective.
Perfect. Another question. This is anonymously sent in. For businesses that are post-startup but have not begun to make profit, what should our focus be? Should we still seek financing to build? My company is a sports apparel company.
I mean, I think right now everyone's main focus just needs to be survive, do what you have to do to survive, and get your business through the next month. If you are in the middle of, I wouldn't like slam on the brakes for anything, but just keep trying to stay in the black. I was like, stay in the green. Keep trying to stay in the black and not in the red if you can.
And this is the last question I see, so I know we do have a couple more minutes. If you have a question, make sure to type it in the chat box or Q&A. But this one's from Holly Miller. She says, for those of us who agree to postponing/rescheduling a service, is there a standard time frame that we are legally obligated to honor the rescheduled date?
If it's not in your contract, no. Like unless your contract says you have to reschedule within a year or within a reasonable time or something like that, there's no like legal, it must be within a year, et cetera, et cetera. You could possibly argue that like a reasonable time frame, like you can't reschedule for 20 years from now, might be reasonable. So I would just whatever you do decide to do, whatever you do decide to do, just get it in writing.
That's a great question.
Mm-hmm.
And I will follow up. I know we only have 5 minutes left. I know you had your last slide was your contact information. Can you reiterate for anyone that does want to contact you on the side and ask any questions that they weren't able to ask today?
Sure. My email is the best way to reach us just because our phone is kind of crazy right now. But so my email is Caroline, CAROLINE, at C as in Caroline, J as in Jessica, Fox like the animal, law like the practice, .com. So it's just Caroline at cjfoxlaw.com.
Perfect. And I am also putting it in the chat for anyone that didn't get that, so you have that to your use. But that's all the questions that I see for right now. So I guess I'll pass it over to you, Andrea.
Thank you so much, Jasmine. Thank you so much, Caroline. Thank you for everything that you shared with us today. And folks, I do recommend if you want to go more in depth into your issues that particularly affect you, please contact Caroline. She's just an amazing, amazing person. And thank you so much for giving of your time today. We really appreciate it.
Thank you guys.
Oh, thank you. So now I'm going to turn it over to Melody so she can close us out.
Helpful. Okay. This was such a helpful session for us all. As you can see, it was beneficial to business owners in multiple industries. So I thank you from the bottom of my heart for creating space for us. I know that you've been slammed with a lot of business in lieu of COVID-19, so thank you for making time. I want to thank the participants today for spending your lunch hour with us. We're hopeful you're leaving this session more informed and encouraged. We ask that you join us for the 5 remaining sessions of the Metropolitan Business Week Town Hall Series, which will be scheduled every Tuesday and Thursday at 12 p.m. through Tuesday, April 21st. Join us for our next session, Tuesday, April 7th. We'll have representatives from local financial institutions, small business and supply diversity, the Office of Minority Business Development and Economic Development, all sharing the most up-to-date economic relief opportunities for the small business community. And as always, continue to follow us, the Metropolitan Business League, on Facebook at the MBL and on Instagram at MBLRBA for the latest information on resources, programming, and special events in support of minority and women-owned businesses. Thank you again for your time and have a wonderful day.